Good afternoon, ma'am. Good afternoon, classmates. I am Elamea Santos, and this is a continuation of our group report. Republic Act 9262, established in March 8, 2004, an act defining violence against women and their children, providing for protective measures for victims, prescribing penalties. Section 1. Short title: This act shall be known as the Anti-Violence Against Women and Their Children Act of 2004. Section 2. Declaration of Policy. It is hereby declared that the state values the dignity of women and children and guarantees full respect for human rights. The state also recognizes the need to protect the family and its members, particularly women and children, from violence and threats to their personal safety and security. Section 3. Definition of terms as used in this act. Violence against women and their children refers to any act or series of acts committed by any person against a woman who is his wife, former wife, or against a woman with whom the person has or had a sexual or dating relationship, or with whom he has a common child, or against her child, whether legitimate or illegitimate, within or without the family abode, which result in or is likely to result in physical, sexual, psychological harm or suffering, or economic abuse, including threats of such acts, battery, assault, coercion, harassment, or arbitrary deprivation of liberty. It includes, but it is not limited to, the following acts. Physical violence refers to the act that include bodily or physical harm. Sexual violence refers to an act which is sexual in nature, committed against a woman or her child. Psychological violence refers to acts or omission causing or likely to cause mental or emotional suffering of the victim, such as but not limited to intimidation, harassment, stalking, damage to property, public ridicule or humiliation, repeated verbal abuse, and marital infidelity. Economic abuse refers to acts that make or attempt to make a woman financially dependent. Section 4. Construction. This act shall be liberally construed to promote the protection and safety of victims of violence against women and their children. Section 5. Acts of violence against women and their children. The crime of violence against women and their children is committed through any of the following acts: causing physical harm to the woman or her child, threatening to cause the woman or her child physical harm, attempting to cause the woman or her child physical harm, placing the woman or her child in fear of imminent physical harm. Section 6. Penalties. The crime of violence against women and their children under Section 5 hereof shall be punished according to the following rules. Acts falling under Section 5 constituting attempted, frustrated, or consummated parricide or murder or homicide shall be punished in accordance with the provision of the revised Penal Code. Section 7. Venue. The regional trial court, designated as a family court, shall have original and exclusive jurisdiction over cases of violence against women and their children under this law. In the absence of such court in the place where the offense was committed, the case shall be filed in the original trial court where the crime of any of its elements was committed at the option of the compliant. Section 8. Protection orders. A protection order is an order issued under this act for the purpose of preventing further acts of violence against a woman or her child specified in Section 5 of this act, and granting other necessary relief. The relief granted under a protection order serves the purpose of safeguarding the victim from further harm, minimizing any disruption in the victim's daily life, and facilitating the opportunity and ability of the victim to independently regain control over her life. Section 9. Who may file petition for protection orders? A petition for protection order may be filed by any of the following: the offended party, parents or guardians of the offended party, ascendants, descendants, or collateral relatives, officers or social workers of the DSWD or social workers of local government units, police officers, preferably those in charge of women and children's desk, punong barangay or barangay kagawad, lawyer, counselor, therapist, or healthcare provider of the petitioner, at least 2 concerned responsible citizens of the city or municipality where the violence against women and their children occurred, and who has personal knowledge of the offense admitted. Section 10. Where to apply for a protection order. Application for BPOs shall follow the rules on venue under Section 409 of the Local Government Code of 1991 and its implementing rules and regulations. Section 10. How to apply for a protection order. The application for a protection order must be in writing, signed and verified under oath by the applicant. Section 12. Enforceability of protection orders. All TPOs and PPOs issued under this Act shall be enforceable anywhere in the Philippines, and a violation thereof shall be punishable with a fine ranging from 5,000 pesos to 50,000 pesos and or imprisonment of 6 months. Section 13. Legal representation of petitioners for protection order. If the woman or her child requests in the application for a protection order for the appointment of counsel because of lack of economic means to hire a counsel de parte, the court shall immediately direct the public attorney's office to represent the petitioner in the hearing on the application. Section 14. Barangay Protection Orders. Who may issue and how? Barangay Protection Orders refers to the protection order issued by the punong barangay ordering the perpetrator to desist from committing acts under Section 5 and of this Act. A punong barangay who receives application for a BPO shall issue the protection order to the applicant on the date of filing after ex parte determination of the basis of the application. If the punong barangay is unavailable to act on the application for a BPO, the application shall be acted upon by any available barangay kagawad. If the BPO is issued by a barangay kagawad, the order must be accompanied by an attestation by the barangay kagawad that the punong barangay was unavailable at the moment for the insurance of the BPO. The BPOs shall be effected for 15 days. Section 15. Temporary Protection Orders. Temporary protection orders refers to the protection order issued by the court on the date of filing of the application after ex parte determination that such order should be issued. Section 6. Permanent Protection Orders. Permanent Protection Orders refers to the section order issued by the court after notice and hearing. Section 17. Notice of Sanction and Protection Orders. The following statements must be printed in bold-faced type or in capital letters on the protection order issued by the punong barangay or court. Violation of this order is punishable by law. Section 18. Mandatory period for acting on applications for protection orders. Failure to act on an application for a protection order within the reglementary period specified in the previous section without justifiable cause shall render the official or judge administratively liable. Section 19. Legal separation cases. In cases of legal separation where violence as specified in this Act is alleged, Article 58 of the Family Code shall not apply. The court shall proceed on the main case and other incidents of the case as soon as possible. The hearing on any application for protection order filed by the petitioner must be conducted within the mandatory period specified in this Act.
Section 20. Priority of application for a protection order. Ex parte and adversarial hearings to determine the basis of applications for a protection order under this Act shall have priority over all other proceedings. Republic Act 9710, Magna Carta of Women. The Magna Carta of Women is a comprehensive women's human rights law that seeks to eliminate discrimination through the recognition, protection, fulfillment, and promotion of the rights of Filipino women, especially those belonging in the marginalized sectors of the society. It conveys a framework of rights for women based directly on international law. The Magna Carta of Women establishes the Philippine government's pledge of commitment to the Convention on the Elimination of All Forms of Discrimination against Women.
Salient features of the law include increasing the number of women in third-level positions in government to achieve a 50-50 gender balance within the next 5 years, while the composition of women in all levels of development, planning, and program implementation will be at least 40%. Leave benefits of 2 months with full pay based on gross monthly compensation for women employees who undergo surgery caused by gynecological disorders, provided that they have rendered continuous aggregate employment service of at least 6 months for the last 12 months. Non-discrimination in employment in the field of military, police, and other similar services that include according the same promotional privileges and opportunities as their men counterpart, including any pay increases, additional benefits, and awards based on competency and quality of performance. Provision for equal access and elimination of discrimination in education, scholarships, and training. Thus, expulsion, non-readmission, prohibiting enrollment, and other related discrimination of women students and faculty due to pregnancy out of marriage shall be outlawed. Non-discriminatory and non-derogatory portrayal of women in media and film to raise the consciousness of the general public in recognizing the dignity of women and the role and contribution of women in family, community, and the society through the strategic use of mass media. Equal status given to men and women on the titling of the land and insurance of stewardship contracts and patents. In addition to guaranteeing substantive rights, the Magna Carta of Women establishes the responsibility of the government to take actions in order to end discrimination against women. It provides that the Philippine government must ensure the substantive equality of men and women, and mandates the state to take steps to review, amend, or appeal existing laws that are discriminatory towards women. The government, in its entirety, shall fulfill these duties through the development and implementation of laws, policies, regulatory instruments, administrative guidelines, and other appropriate measures. It shall also establish mechanisms to promote the coherent and integrated implementation of the Magna Carta of Women and other related laws and policies to effectively stop discrimination against Filipino women. The Magna Carta of Women mandates all government offices, including government-owned and controlled corporations and local government units, to adopt gender mainstreaming as a strategy for implementing the law and attaining its objectives. It also mandates planning, budgeting, monitoring, and evaluation for gender and development. The creation and strengthening of gender development focal points and the generation and maintenance of gender statistics and sex disaggregated databases to aid in planning, programming, and policy formulation. And that ends my report. Thank you.